Hello and welcome to Legally Speaking with me, Tarun Nangia. The Supreme Court bench, led by Justice Suryakant, has expressed a very strong concern over universal free electricity policies. This time, of course, this was a matter concerning Tamil Nadu, but I think Justice Suryakant's observations are also universal. He's saying that indiscriminate freebies, like, many times even well to do people who get free power would use it indiscriminately, and it has a ripple effect on the distribution companies, the generation companies, and the banks. So it's heartening to see a Chief Justice of India who's understanding that the fiscal underpinning of the Indian economy can completely rupture because of political gains that are sought by giving free electricity. And I think this message by Chief Justice Suryakant will be heard across by the investor community, the industry, and the banks. That's why we take it up today. I want to welcome my panelist for today's show, Senior Advocate Buddy Ranganathan, joins us from the city of Delhi. Good to see you. Thank you for your time. We have Advocate Sri Venkatesh, who also joins us. Of course, he's out of town, but he's kindly consented and named time for this show. Good to see you. Venkatesh, thank you for your time. Advocate Madhu Gadodia joins us from the city of Mumbai. She's Deputy Managing Partner of law firm Nayak and Nayak. Good to see you, Madhu, and thank you for your time. At the outset, let me request Advocate Sri Venkatesh to sort of give a sort of an explainer on why Justice Suryakant's comments are so important and have been taken so well by the industry. Could you sort of give this explainer? You work a lot in the power sector. I think you could give us a good 2-3 minute explainer on why Justice Suryakant's comments are important.
Thank you, Tarun. So let me give you the context of what this matter is all about. Last year in 2025, the Honorable Supreme Court delivered a judgment where Mr. Ranganathan was the bulwark of that whole litigation, right from the Court of First Instance to Supreme Court. I also had a role to play there. The judgment was very simple, that the regulator cannot artificially suppress the real cost or real tariff, because that is not healthy neither for the distribution companies nor for generating companies, and not even for consumers, because consumers also end up paying a lot of interest. So that judgment was passed on 6th of August 2025. One of the most critical features of that judgment, which was passed by the bench comprising Justice Narasimha, was that it made the Appellate Tribunal of Electricity as an agency to monitor that this regulatory asset is amortized within 7 years from the date of the rules, the so-called rules being framed by the central government. That was the scope of one of the positive directions of the judgment. Now, in doing so, Tamil Nadu actually has a huge regulatory asset. I mean, it's I think probably the highest in the country, 1 lakh odd crores. The reason why Tamil Nadu can afford this higher regulatory asset, because there is no private distributor. The distribution company is owned by the state government. So they are very happy for whatever reasons not to raise any tariff and continue, charging paltry sums from consumers, even though the cost has gone up. So Tamil Nadu actually, while was facing difficulty in APTER, because they had to recover this money from this 1 lakh odd crores from the consumers and give it to the distribution company. So Tamil Nadu government said, look, we will write off this money. We don't want to recover from end consumers. We will write it off completely, so that there is no enhancement of costs. APTEL did not obviously agree with it, because that they were following the judgment of the Honorable Supreme Court. They said, look, you have no option but to recover this money in tariff in the next 7 years, because that is the direction. So they challenged, actually, interestingly, they filed a writ petition challenging the rule under Article 32, and the Tamil Nadu Commission challenged the APTEL order, saying that, look, if the state government is willing to write off the money, why should anybody have a problem? That's how the matter came to the Supreme Court. This is a bit of I mean, I took a minute to explain the way it came up to the Supreme Court, but that is how the matter came up. Now, interestingly, there's 1 lakh crore rupees of amounts which are recoverable by the Tamil Nadu distribution company. The Honorable Justice Suryakant asked a very pertinent question. You have a right to give subsidy, no doubt that even Electricity Act says that subsidy can be provided to a category of consumers. You can give subsidy. But what is the basis for you to write off the entire recoverable amount? Because not everybody requires a subsidy. If you remember, the LPG gas before, for 15 years before that, was subsidized for everybody. Then government came up with a very simple scheme that, look, if you don't need this subsidy, you can volunteer opt out of it, and it'll only apply to those who actually require that subsidy. Something similar is required to be done in such cases, that you, just because you feel that electricity is a very highly politicized subject, you feel that this will affect the mass sentiment if there is a tariff hike, you can't have a situation where nobody is bearing the brunt of the real cost. If you want to protect a section of society, that's the function of a sovereign state. You can do so, but you can't make a one size fit all sort of an approach and say that nothing is payable or recoverable by the distribution company, because ultimately, where does this all, if you don't recover from end consumers, where does the problem lie? The problem lies for the distributors to pay their banks. Problem lies to pay to generators. Ultimately, most generators are either PSUs or private companies, so they will suffer if they don't get, if the value chain is not, it does not percolate from the start to the end. So in that context, I think the comment is quite welcoming. Of course, they've issued notice because they want to examine this issue, how they want to, how far would they interfere in the matter. So the matter is still alive before the Honorable Supreme Court. We don't know which way it will go, but that is the context in which these comments were made before the Supreme Court by Honorable Justice Suryakant. Tarun, you're on mute.
Point very well taken, and thank you sharing the explainer. We'll go to Senior Advocate Buddy Ranganathan for his opening comment on Justice Suryakant's observations.
Thank you, Tarun. Thank you for inviting me here to the show. Thank you, Venki, for this curtain raiser. It's actually put the entire thing correctly in the perspective. Obviously, Chief Justice Suryakant's comments are obviously very preliminary comments. I mean, those are his first observations and his first reactions to the petition that was presented before him. The matter is still sub judice. We will see how it goes. We don't know what arguments are going to be presented by the government of Tamil Nadu, etc. We'll see how it goes. We don't know which way ultimately the judgment will come out. But yes, these are extremely heartening comments. The reason is, in the electricity sector, there is only one revenue stream. The revenue gets collected by the paying consumer, paid to the distribution company. The distribution company then pays it onwards to the transmission company or to the generating company, and the generating company has to pay to the fuel producer. Now, if this revenue stream is blocked midway, you're going to have a cascading effect on every part of the revenue stream. It's like a bottleneck. If you're going to stop the revenue at some point of time, everything upstream of that bottleneck is going to get affected. Ultimately, what's going to happen? Ultimately, generators are not going to be able to pay banks. Banks are going to have NPS. We are back to square one. So today, the entire issue stemmed from the fact that the Tamil Nadu Commission, and like a lot of other commissions across the country, have created this huge regulatory asset. Now, what is regulatory asset? It's a nice sounding phrase, but what does it mean? And it means, in the simplest possible terms, a cost has been incurred by the distribution company in terms of power procurement. It has purchased the power, it has paid its employees, it has put in its capital expenditure, it has put in its revenue expenditure, it has got that electricity to be sold to the end consumers. It has paid that amount. It has paid 83,000 crores and not been able to recover that from its consumers. That is what regulatory asset is. So today, effectively, what you're saying is that the commission did not do its job all these years. The commission created this impasse. And today, you're saying the ratepayer, who was supposed to pay these charges all these years and who was exempted from paying it, doesn't need to pay it, but the taxpayer needs to pay it. And you and I, who have not consumed that electricity, who are not consumers of that electricity, have to pay from our taxes. So it's the age-old impasse, whether who pays for services. Is it the ratepayer or is it the taxpayer? Surely Section 65 of the Electricity Act contemplates that a state government can give subsidy to a distribution company. Please do so. Nobody stops you from doing so. There is a large section of society which needs protection from various commercial rates. There's no doubt about it. There is a section of society which needs that assistance, which needs that help, where a commercial tariff or a fully cost-loaded tariff is simply not viable to pay. I mean, let's face it, we are not in the United States of America, we are not in the United Kingdom. There's no doubt about it. But please do it in a legal fashion. Please do it in a fashion that is accepted under the Act. Why did the Electricity Act come in? The Electricity Act came in because the state electricity boards, which were hitherto fixing tariffs and unable to raise commercial tariffs, were run into the ground. It was to prevent them from collapsing that the Electricity Act 2003 was enacted. And today, what are we doing? We are back to status quo ante, where the state electricity board, in the name of a distribution company, is again being run into the ground. We have hundreds of litigations across the spectrum where the distribution companies of Tamil Nadu have not paid their generators. Generators are queuing up in civil courts and writ petitions in the CERC, in the TNERC, in the APTEL, in the Supreme Court, waiting for their money. I have been part of several of those litigations, whether for tangent core or against tangent core, and I've appeared for both. But the point is, why are they not paying? They're not paying because they don't have the money. Why don't they have the money? Because they were never allowed to recover it. So today, the Tamil Nadu government is standing up and saying, we are going to take it over. But what does take it over mean? Where does 83,000 crores come from? Does the Tamil Nadu government have 83,000 crores to give to the state discom? And then say, all right, now please pay your generators and please pay people whom you owed money. We're not talking about monopoly money here. This is real money, 83,000 crores. So there is a serious issue here. And I'm very glad that the Honorable Supreme Court has decided to take it up and take forward what the Supreme Court already said in the BSES judgment. And that's, I think, what we're all looking forward to. Thank you.
Point very well taken. In fact, I remember even the government had launched an ambitious scheme called the Ujjwal Discom Assurance Yojana 6-7 years ago, with the only intent to reduce Discom, in a sense, receivables and the kind of loans that had come, so that fiscal discipline comes in.
I think there have been 11 schemes that all have failed one after the other since 1948. 11 schemes to sort of help out discoms all these years, but it doesn't work because if you don't recover the cost, it will not work. But anyway, sorry, I just wanted to.
So I'll go to Advocate Madhu Gadodia, Deputy Managing Partner, Nayak and Nayak. Madhu, what do you feel about the universal free electricity schemes? Do you think that the state's financial discipline completely goes out of the window? If these kind of schemes, the politicians, for whatever reasons, push. And now the court, of course, is also coming at it. The court also is making strong observations. Your opening comment.
Right. So I think this is very pertinent, Tarun, because while there is a lot of talk regarding these comments which have been made, but what has essentially been done is not to discourage a subsidy being given, but to regulate it in a very fair manner, so that there is a good balance between the job of the center and the state, because we all know that electricity is a part of the concurrent list. And therefore, there has to be a very fair balance, one on the fiscal tariff, which is the subject of the center, as well as the welfare schemes, which have to be designed by the state. Now, what does this Rule 23 essentially do? It does not prohibit a subsidy. All it does is to regulate it in some way by saying that the ARR, the gap between the ARR and the estimated revenue from the tariff should not exceed 3%. And the second is that there has to be a time period within which this gap has to be liquidated. And that time period is 3 years in case of new gaps and 7 years in case of existing gaps. So again, it is a very well thought of amendment, which is a very fair balance between the state and the center responsibility, and therefore it should be taken in a very positive spirit. Now, of course, the states are complaining about the carrying cost, etc. But then the question that the Supreme Court has said is that if you are giving the subsidy, then ultimately where is it being compensated from? Because there are only 3 sources which are available to the state. One is, of course, the taxpayers' money. The second is, allocation from the other sectors, and therefore, you again create an imbalance. or the third is borrowing. And either of the three is going to create a burden on the state. Alternatively, it is going to create a burden on the discoms. And as the figures, Buddy pointed out, running into thousands of crores, it is only going to increase. So nowhere has the state government discouraged or said that Section 65 of the Electricity Act becomes redundant because a subsidy cannot be given. But there are certain norms which need to be followed. Like one is the information which has to be given in advance so that adequate planning can be done. The second is it has to be done in a well thought of manner where you don't burden a particular section of the customers and especially, don't make it so ad hoc that just for the sake of giving subsidy, you give it also to people who can afford to pay and for whom this subsidy does not mean anything. So there are various subsidies which the government has given in the form of a well thought of manner where it is given to the one who really deserve or need. So, these are certain parameters which are very fair. And these questions have been rightly put by the Supreme Court. And I'm sure that in, the course of hearing and once, of course, notice is issued, once the states answer these, it will inure to the benefit of all.
Point well taken, Madhu. In fact, I'm from here on, I'll take the issue to what is very required for the sector is cost reflective tariff. If a certain cost is being incurred to produce electricity, the tariff should be in line with the produced cost. Uh, and if political parties distort the pricing structure, then what happens to the whole aim of having tariff which is cost reflective? Thankfully, our procurement costs and power have come down to, if I'm not wrong, even as low as 2 rupees or maybe a little bit lower also sometimes in PPAs. If that is the case, then sort of why the freebie culture, and now with the court sort of taking cognizance of this, where are we headed? Because we cannot sort of indefinitely be in this regime of giving free power. We have Aadhaar cards and we have other economic data to identify which people can and can't pay. There are other means to identify. So, given that as a background, I want to request Advocate Sri Venkatesh to make his comment on cost reflective tariff and also the court taking up this issue.
So, Tarun, thank you. So, actually, as Mr. Ranganathan was alluding to earlier, this 2003 Act, it says that tariff has to be cost effective. That was the very reason why this particular statute was enacted, because before that, for political reasons, tariff was not cost effective, and the entire loss was being absorbed by the board. Now, please, I'll give you a trajectory of two states, how things have sort of culminated therein. Maharashtra is one state where even if a discom does not, where there's parallel licensing, there are multiple licensing operating in Maharashtra. Even if a discom says, please create some regulatory asset because I don't want to so-called burden my consumers or lose out on competition because my tariff will go high. MERC says nothing doing. We are not giving a penny of regulatory asset. You will recover the actual cost of supply, be it 7 rupees, 8 rupees, or 9 rupees for domestic consumption. That's a separate point altogether. That is one state like that. Now look at another state like Delhi. I mean, it's a very interesting case of Delhi. 2021 was the last tariff order that there was issued in Delhi, which was a tariff order where the exact same tariff for the last 4 years were carried on, despite the fact that the cost of coal has gone up, despite the fact that the cost of generally power production in India has gone up. You have, of course, cheaper sources in terms of renewable, etc., but that's only a fraction of your overall balancing pool. You also need a lot of coal-based generation, and the cost of coal is going up. Despite all of this, the Delhi regulator says no tariff hike. Very proudly says so in the tariff order. Now, the messaging is more political than actually regulatory, because they are supposed to fix cost-effective tariffs. And this is where the 2021 was last order. We are in 2026. Delhi has not seen a tariff revision for the last 5 years, and we're still paying the 21 rates, so to speak. So when into it, so now what's going to happen? Look at it as a consumer. Like we all live in Delhi. Now, finally, when they start fixing a cost-reflective tariff, let's say for financial year 26 onwards, they will have to pay this money back to the distribution companies who have charged you lower rates, subsidized rates. That money will have to be paid with carrying cost, some amount of carrying cost. Let's not, I mean, Tamil Nadu government has a problem with the percentage rate in the rule. Let's leave that aside. Let it be any simple interest also. Imagine the burden on us as end consumers at the end of the beginning of financial year, because we will have to pay for carrying costs for the last 5 years and for this regulatory asset, because the tariff was not fixed cost effective. So effectively what happened was, in all these years, that this whole congregation of regulatory asset is nothing but regulators coming and sitting in these positions and kicking the can down the road. They feel that they are there for 3 years, 5 years. If they don't do too much, they don't increase the tariff, they somehow have done their job and they kick the can down the road, because somebody else will come in future and maybe change, or will have to bear the brunt of this. What they don't realize is that the citizens of the state who are suffering, where this whole cost is getting accumulated against us, are going to end up paying for all of this in some form or fashion. Either we will pay as end consumers, or as Buddy sir rightly said, the taxpayers will pay. The government will have to give a bailout. Either which way, the individuals only pay, whether it's in the form of electricity money or it's in the form of income tax. There is no third source of revenue for the state government to help us out. So cost reflective tariff was supposed to be the underpinning of this act. And somehow this has been completely lost sight of in the last 21, 22 years. This is the precise reason why I think, I think the last show that we did on with you, we discussed this. The government is very keen to bring in certain key amendments so that this cost reflective tariff cannot be sort of meddled with. But that's future looking. But the problem is we are already facing the problem now. So this is the issue which we are all grappling with, so to speak.
I'll take this to Mr. Ranganathan. There is a complaint that a lot of industry people make, that you're crowding out spending in infrastructure. Because, if you're continuously, all your money is going to, give power freebies, where are you going to spend money on putting into power infrastructure also? State of the art transformers, wheeling infrastructure, uh, anything, nothing, no money is available for anything, and you have then third world infrastructure. Uh, and there you are. I mean, what do you think should be done? I mean, it's 2026, not that we are in the 90s, things have changed a lot. Uh, where should we be heading? And if the courts are now constrained to point this out, surely the executive has gone wrong somewhere.
Thank you, Tarun. Yes, you're absolutely right. And this is exactly what the Supreme Court pointed out in the BSCS judgment, that today what we are facing is nothing but a culmination of regulatory failure and regulatory capture. And these are the two expressions that the Honorable Supreme Court has used in the judgment. And it can't be a more scathing comment on the situation that we face. Because today, by and large, in an ARR, an annual revenue requirement of a distribution company, that is how much tariff it needs to recover in a particular year, almost 80% of its total requirement, the total cost that it incurs, is on power procurement, right? That's the cost of the power that it buys. It's only 20%, or roughly 20%, of its total requirement which is spent on capital expenditure, which is spent on transformers, which is spent on network, which is spent on employees' costs, which is spent on administrative costs, etc. So today, unless you are going to be able to bring down the cost of that 80%, even if you're going to squeeze that balance 20% into less, let's say 15%, what's your saving? Your 80% of power purchase cost is still there, which has to be paid for and incurred. So unless you find a way of reducing the power purchase cost at the very source, you are never going to be able to bring electricity tariffs down. So simply having non-cost reflective tariffs where you squeeze the margins of the distribution company, you don't allow them to invest, is only going to lead to very, very temporary gains. The elephant in the room is power purchase cost. You need to deal with that. whether you are going to reduce the cost of coal, whether you're going to reduce the GST on coal, whether you're going to allow coal to be privatized, are very, very large questions indeed as to how we're going to bring down the cost of coal. What you said about solar tariffs is absolutely correct. Some of the solar tariffs today have gone down to 2 rupees. 230 or so is among the lowest bids that we've seen in recent times. But it's still a very, very small
Even
component.
some thermal tariffs are about 219, 218, 220, that range.
That's true. That's true. And those are the supercritical plants, which is there. But again, that's a very, very small percentage of your total power purchase basket, which every discom has. Most of the discoms have a power purchase basket which includes long-term PPAs with, say, NTPC generating stations or other central generating stations, where your average power purchase cost is 7 rupees, 8 rupees, 9 rupees. So that's the largest bulk of your power purchase basket. How are you going to reduce that?
So you can't walk out of, I mean, Delhi, I think when I saw last, it was 6 rupees 60 paise per unit procurement. So you can't walk out of something like that.
Exactly. So today, to say that you have one generating station in Madhya Pradesh who is giving solar at 2 rupees 30 paisa is not going to help the power sector as a whole. So therefore, you have to, if you want to reduce electricity tariffs, you have to go to the root cause. Simply looking at the end product and saying that I am going to reduce your capital expenditure by 1% or your employees' cost by 1% or your efficiency by 2% or something like that is these are only cosmetic changes.
Point very well taken. I'll go to Advocate Madhu Gadodia here. Madhu, clearly the executive is failing here to maintain financial discipline. And it's a classic case of the courts coming and correcting the executive, that don't just throw away money for free. Do you think that this whole trend of giving freebies, to everyone, these are not targeted, of course, when you're sort of saying that all bills need to be waived out, it's not targeted. It is just throwing away money. What is happening really here in your view?
So obviously, when anything is offered, there has to be some purpose for the offer because, I mean, it cannot be like headless or without any direction. So, and this is usually done, pre-elections. So obviously the idea could be, this could be a political motive to get more votes or bank the vote bank. And we have seen in the recent past when, good subsidies, good schemes have been introduced, it has resulted in, good vote banks for many political campaigns. So this could be a very strong motive. And apart from that, I don't see anything else because it is not going to be benefiting the consumers at large because a significant portion, while you are offering them the free electricity, they are ultimately paying through the tax money. So it's like just a feel good factor that you're getting something for free, but ultimately you're ending up paying it. It's a very small section which is actually getting it free. So, and like I said, there's no free lunch. So obviously there has to be some motive behind it. And this is perhaps the only motive which I can see and which is rightly questioned and observed by the court as well.
In fact, from your last statement, there's no free lunch. In fact, there was a time not long ago in India when there was no power during lunchtime. From those days, we have sort of come to a time when at least now we have 24/7 power, not in rural India, but at least urban pockets have. By giving things free, we should not squander that away. In fact, next week, we're going to discuss that should we have sort of a long-term policy on critical sectors where freebies should be avoided strictly. Because see, if the matter has come to the courts and the courts are constrained to intervene, surely the executive failed in doing its duty somewhere. Of course, we will see where this case goes, and we will get an opportunity to discuss it again. I would like to thank Senior Advocate Buddy Ranganathan, Advocate Sri Venkatesh, Advocate Madhu Gadodia, Deputy Managing Partner of NAC and NAC. Thank you for your time on this very critical issue which considers law and economics. This sort of impacts both sectors. Appreciate your joining us. Thank you so very much.
Thank you very
Thank you.
much, Tarun.
Thank you,
Thank you, Tarun.
Thank you.
Thank you.